Good afternoon and welcome to our webinar today on how to effectively apply EPA's audit policy. I am joined today by one of my friends and colleagues, Rita Bolt Barker. In just a moment, I will introduce both of our companies as well as your speakers for today as we navigate this topic. But just a couple of little housekeeping notes before we dive right in. For our webinar today, feel free to use the questions or chat toolbar to ask any questions that you might have. And we'll make sure that we'll take some time at the end of the presentation to answer any of those questions that you might have. Also, in a few moments, my colleague is going to be uploading some handouts for the group. So yes, you will have a copy of the slides and everything we're presenting. So hold tight. My colleague will be uploading those in just a moment to make sure everybody has time to get into the webinar so that they're able to access those handouts. So with those little housekeeping tidbits out of the way, let me introduce the two companies that are bringing you this topic today. So HRP is one of the presenters for our topic today. Since the early 1980s, HRP has worked with our clients to assure that they move their environments forward. And what we mean by this is that we work with our stakeholders to minimize the environmental and compliance risk associated with their projects and their operations and to help align with their business goals. We are a multidisciplinary environmental compliance and engineering consulting firm with several offices across the country. HRP has assisted scores of businesses and industries with disclosures under the EPA audit policy, most notably in the early 2000s. We worked with colleges and universities in tailoring a negotiated audit policy agreement with over 200 colleges and universities that resulted from some EPA enforcement action on higher education. So a lot of experience with the topic we're presenting today. And my friend and colleague Rita is joining us from Weish. Weish is a full service law firm that has practiced law and served the community for over 100 years. In that time, Weish has participated in landmark litigation, served as counsel on cutting edge transactions, and provided community leadership that has helped shape and drive their region's growth and success. With offices across the state of South Carolina, Weish is the South Carolina member of the Lex Mundi, the world leading association of independent law firms. They practice in the fields of environmental, corporate, commercial real estate, employment, and litigation. And then Rita and I will be your speakers today. So I'm Jackie Baxley. I lead our environmental health and safety and sustainability practice here at HRP. I've been working in the field for, we'll just say, over 27 years. And during my time at HRP, I've worked with a lot of our stakeholders and business communities relative to not only conducting audits and developing compliance management systems, but also helping to identify and lead companies through the self-audit policy should there be findings that merit self-disclosure. Now, Rita is a member of Weish PA, is an experienced environmental attorney. She represents clients in federal and state court as well as before the Environmental Protection Agency. Her varied experience includes advising clients on matters arising under federal and state environmental statutes, including PICA environmental statutes, the whole alphabet soup of the environmental statutes, from Clean Water Act to endangered species to RCRA as well. Rita counsels clients on assessing environmental risk and incentives associated with corporate transactions such as mergers, acquisitions, and real estate deals, including numerous brownfield development projects through South Carolina Voluntary Cleanup Program. Rita has written and presented on numerous environmental law topics and has been an adjunct professor at Clemson University in Furman. Actually, right before we started, we were all talking about college football and Clemson football kicking off this week. So a
Go
passion.
Tigers.
Wonderful. Now, our agenda for today. So, again, we'll be covering the topic of the EPA self audit policy. And in doing so, we're going to first introduce you to this policy. And then we're going to go through a couple of scenarios and examples of specific applications, which might help you in deciding if you have potential violations in the future that could merit protections under the audit policy. And then we're going to wrap up with some recommendations and best practices. My colleague Dominic has just uploaded the handouts associated with today's presentation, so you should have a copy of all of these slides. And we also have a supplemental handout as we will talk about some links and some definitions and references. And those are just easily available to you through that supplemental handout. So y'all should all have access to that in the chat. All right, so let's go ahead and dive right in. And Rita, at this point, I will hand it over to you to guide us through the EPA audit policy.
Thanks, Jackie. I'm excited to be with all of you today. I'll just provide some policy background before we get into the details of the EPA audit policy. The policy is entitled Incentives for Self-Policing Discovery, Disclosure, Correction, and Prevention of Violations, better known as the audit policy. It was passed in the year 2000. Its goal is very simple: to enhance the protection of human health and the environment, which it accomplishes by incentivizing the regulated community. In formulating this policy, EPA was focused on the fact that it, as a government agency, has limited resources and the regulated community has much more awareness into its own environmental management processes. The policy has been in place far longer than since 2000. The 2000 policy actually replaced a previous 1995 audit policy. Next slide, please. The way the EPA audit policy encourages the regulated community to self-police is through two primary incentives. The first is elimination or substantial reduction of gravity-based civil penalties. And if you're wondering what gravity-based penalties are, those are that's the portion of the penalty over and above that which represents the economic gain that an entity might have had as a result of the non-compliance. We might call these the more punitive side of penalties. EPA retains its ability to recoup economic benefits under the audit policy. The second incentive is a recommendation of no criminal prosecution. EPA's practice is that it generally does not pursue criminal enforcement against entities that are voluntarily disclosing and correcting violations, unless there is extremely culpable behavior. I'll note that this incentive is available even where a particular condition that Jackie is going to talk more about, systemic discovery, is not present. And this is probably a good time to turn it over to Jackie to talk about the conditions required to take advantage of these incentives.
Thank you, Rita. So as Rita mentioned, there are 9 conditions to be able to fully benefit from all of those incentives. And the first of the 9 conditions is systematic discovery of the violation through either an environmental audit or the implementation of a compliance management system. As Rita alluded, you can still gain some incentives even if you don't meet all of these 9 conditions. And this first condition is a perfect example. So EPA has stated if you meet all of the 9 except for the systematic discovery, well, then you're still eligible for up to 75% of those penalty waivers. So still a substantial discount, if you will, of any potential monetary penalties associated with the disclosure. The second condition is voluntary disclosure of the violation. That was not detected as a result of a legal required monitoring, sampling, or audit procedure. One way to think of this is relative to the voluntary disclosure is it can't be a permit obligation. So if it is a permit obligation, then you are typically obligated at some routine basis to be assessing your compliance with your permits. For example, a Title V air permit, you have an annual compliance certification. So typically, non-compliance with a permit would typically not meet this definition of a voluntary discovery. And then the third condition is prompt disclosure. And prompt is defined here as 21 days. So prompt disclosure in writing to EPA within 21 days of discovery or such shorter time that may be required by law. So if it's maybe a state program that you're also working with, for example, and the discovery, when we say discovery, that is when we have knowledge of the violation. So discovery occurs when any officer, director, employee, or agent of the facility has an objective, reasonable basis for believing that a violation has or may have occurred. So you can actually disclose potential violations under this policy as well. And then the fourth condition is independent discovery and disclosure. So you are independently identifying this compliance gap. You are independently disclosing this gap. So EPA or some other regulator has not already identified this. So these are things that you are self-identifying, self-disclosing, i.e. the self-audit policy. The fifth condition is you have to correct what you disclose. So this is a find it, fix it policy. So condition 5 is the fixing it piece. And so you have to correct and remediate whatever was disclosed within 60 calendar days. It's important to note here, it's 60 days from the date of discovery. So that date of discovery is key in using this audit policy. So that date of discovery starts your 21-day time clock for disclosure, and it starts your 60-day time clock for corrective action. And not only do you have to correct the issue, but under the condition 6, you have to prevent recurrence of the violation. So you're going to correct the issue. You're going to hopefully get to the root cause of the issue, address that root cause of the issue so that that violation would not reoccur in 6 months' time, in a year time, and 3 years' time. And then the seventh condition is to be aware that repeat violations are not eligible for this audit policy or these disclosures. So the specific or closely related violations have occurred at the same facility within the last 3 years, or those that have occurred as part of a pattern at multiple facilities owned or operated by that same entity within the last 5 years would be ineligible here. And so it's important to note, if you are a larger organization, if you have multiple facilities across the United States, a repeat violation could be from a self-disclosed violation at, or even a violation that was identified by a regulated entity at a sister facility. And then certain types of violations are ineligible as well. So not only are the repeat violations ineligible, but violations such as those that result in serious actual harm, those that may have presented an imminent and substantial endangerment, and those that violate the specific terms of an administration or judicial order or consent agreement. We look at this as discharges. So spills, releases, unpermitted discharges would typically fall under this category. And then the last condition, the ninth condition, is just cooperation. So by entering into this policy, you are going to be working with EPA in answering any questions and working with them in their review of your disclosed items. Now, the actual disclosure process itself went to an online disclosure process a few years ago. And so it is a web-based disclosure portal now. And you do this web-based disclosure through what's called the Central Data Exchange. Anybody that's filed a TRI report under EPGRA or anybody that has updated a risk management program, pretty much any type of reporting that you're doing to the EPA anymore is going to be through the Central Data Exchange. So if by chance you've never registered through the Central Data Exchange, that's going to be step one, is to register through the Central Data Exchange so that you're able to access this platform for the disclosures. The second step is going to be then to go to the e-disclosure module on Central Data Exchange and actually submit your voluntary disclosure. And so remember, for policy conformance, you're going to have to disclose that within 21 days. So you're going to, well, before you get to that 21-day mark, you're going to want to make sure that you're already registered in CDX because that can take time. Sometimes signatures have to be verified by mail. So make sure that you have that CDX account well in advance. And there's also a signature verification process for the e-disclosure platform as well. So start that part of the process a little early. So you're going to submit it through e-disclosure. And there are a couple of guides to help you before you go through that online process. Those guides are available to you in our handout through links. And those links that we provided you is the e-disclosure checklist that EPA has to reference that you've got all the appropriate information you need to start the disclosures, and then also the help guide. And the help guide is kind of a step-by-step of how do you enter the information. It gives you the screenshots and everything to make sure that you're navigating that system appropriately. And it is important to note, you can disclose potential violations. You can retract a disclosure as well. So if you're butting up against that 21 days and you're like, I discovered it 19 days ago. I think it's a violation. I'm not 100% sure. You're still gathering data. You can go ahead and disclose it, and you can recant that disclosure later, and you can also disclose and go through the process with potential violations as well. And then the third step, so step one, register with CDX. Step two, disclose the issue through the voluntary disclosure. And step three is to certify that you've actually completed the corrective actions associated with what you disclosed. And remember, the 60-day corrective action period does not start the day you disclose. It starts the day of discovery. So by the time you disclose it, you're already 1/3 into your way of your corrective action process. So use your time wisely. It is important to note extensions are available. Reasonable extensions are available and typically granted by EPA if for those types of things that just take a little bit longer to correct. Now, there's two categories of disclosures. Category 1 disclosures are for those violations to EPCRA only. EPCRA is the Emergency Planning Community Right to Know Act. By count, it is the most numerous type of disclosures that EPA sees under this audit policy. Well over 50% of the disclosures seem to be in the EPCRA regulatory bucket, which is why they have this more streamlined process. Category 1 disclosures, if it's an EPCRA violation that meets all of the 9 policy conditions. And then there are some variations for small businesses. Hang tight. I'm going to tell you what those variations for small businesses are. But EPCRA violations only where you meet all 9 conditions. You would not use this condition, or excuse me, this category 1 for any releases under EPCRA. And EPCRA violations with significant economic benefit that EPA defined, and Rita spoke a little bit about economic benefit earlier. But just for your run-of-the-mill EPCRA, you failed to do a TRI report on a particular chemical, failed to do a Tier 2 report, that's what the Category 1 disclosures are there for. Now, the Category 2 disclosures would be everything else. So all non-EPCRA violations, or even EPCRA violations where you're not able to certify that you've met all 9 conditions. So maybe you met condition 2 through 9, but that systematic discovery was not one that you could certify to, so you would use the category 2 option at that point in time. Now, there are a couple of policy variations. So Rita introduced us to the audit policy as a whole. Well, EPA has tweaked that audit policy for 2 unique scenarios. The first unique scenario being a new owner audit policy. And this is one that I think is a huge value to new owners of facilities. So under the new owner audit policy, there are tailored incentives to encourage new owners to look closely at compliance issues for their recently acquired facilities. It's a way for new owners to start with a clean slate. by utilizing the new owner variation of the audit policy. So with this variation, it's still the same 9 conditions, but those conditions have been tweaked to accommodate the nuances of mergers and acquisitions and new ownership and transactions. And so, if you think about those 9 conditions I just shared with you, some of the tweaks that you see with those 9 transaction or those 9 conditions is it removes the periodic aspect of systematic discovery. Because you just bought the place, how can it be systematic? So you don't it does not have to be part of a periodic or routine assessment under that condition 1. It also expands voluntary disclosure. Remember, just a moment ago, I told you if it's a permit violation, it likely is not going to meet that condition 2. Well, under the new audit policy, there are incentives for new owners to identify all issues of compliance, even those associated with permits. So you are able to potentially disclose and gain those incentives and protections for violations associated with permit obligations. Also, the prompt discovery is tweaked a little bit as well. So, first of all, to benefit from the new owner audit policy, you have to use it within the first 9 months following the closing. So, you get to benefit from these in the first 9 months. And because of just the timelines and all the stress that's dealt with any merger and acquisition, those timelines are tweaked relative to that 21-day disclosure. So prompt disclosure flexibilities that you see here is if you identified the violation before closing, then you would disclose it within 45 days of the closing. If you identified the violation after the closing, then you would either disclose it within 21 days of discovery or 45 days of closing, whichever one is longer. So it gives you a little bit more flexibility there because of just the nuances of timelines associated with mergers and acquisitions and new purchases and so on. And then there's some flexibility also in the violations that resulted in serious harm, such as a release or a discharge. Again, the incentive is for new owners to start with a clean slate, to identify what needs to be fixed, fix it, and pave a path moving forward to where it won't recur again in the future. Where the small business variation, small business being defined as 100 or fewer employees across all facilities and operations, so not per location, but across all facilities and operations, 100 or fewer employees. And the nuances here is it just streamlines from 9 conditions to 3. And those 3 conditions are it's got to be voluntary discovery, so not a permit issue. It's got to be promptly disclosed, 21 days, and you have to fix it. You just have a little bit more time to fix it. Instead of 60 days, you have 90 days to fix it. So those are a couple of variations that could benefit some of our listeners out there. So with that, now Rita and I want to go through a couple of specific applications and some examples. But before we do, we want to drill in a little bit more detail about systematic discovery. I think if we were to just summarize, if AI was to summarize our whole webinar and what is the one take-home message of this webinar, I would say the one take-home message of this webinar is to make sure before you ever get to a point where you think you want to disclose something, make sure you have either an audit process in place or a compliance management system in place, because proving systematic discovery can be the most significant hurdle as you're going through the audit policy. So, systematic discovery means the detection of a potential violation through an environmental audit or a compliance management system that reflects the entity's due diligence in preventing, detecting, and correcting the violation. So definitions are important here. In that handout that we added to the chat, environmental audit is defined and compliance management system is defined. But for us to drill into it a little bit more, so an audit, we all know what an audit is, right? But to meet the systematic discovery element of an audit, the environmental audit has to meet all 4 of the following elements. It has to be systematic, it has to be documented, it has to be periodic, and it has to be objective. You've got to meet all four of those bullets for it to be considered an environmental audit. Now, you do not, to prove systematic discovery, you do not need to provide notice to EPA before an audit. You do not need to have defined timelines that the audit takes 2 days or 3 days or a week and a half. So it's just got to be systematic, documented, periodic, or objective. So, a lot of times we recommend have an audit program in place that defines how you'll do the audit, how it will be documented, what's the frequency associated with it so you can prove that periodic. And then the objective just means you have, an unbiased set of eyes that's looking into identifying those opportunities for improvement. Now, environmental audit is just one way to prove systematic discovery. The other way to prove systematic discovery is for the violation to be identified through a compliance management system. And what we mean by a compliance management system is that it has to be based off of policies, standards, and procedures. And with those policies, standards, and procedures, you're going to have assigned roles and responsibilities. And then you're going to periodically assess conformance with those policies and standards and procedures. And then you're going to communicate and train your employees on those policies, standards, and procedures. You're going to hold individuals accountable for those policies, standards, and procedures. And lastly, when you identify those gaps or those opportunities for improvement, you have a corrective and preventive action program. Those of you that are familiar with ISO 14001, you might be thinking, well, this sounds like an environmental management system under ISO 14001. Exactly. An ISO 14001 environmental management system would be an example of a compliance management system. So just a couple of examples of how one could systematically discover a violation through one of these. So let's say you're doing an environmental audit and you have an audit finding that the site failed to submit a TRI report under EPCRA. That could be something that was systematically identified through the audit process. It would be documented as an audit finding. The audit was part of a periodic or routine frequent audit process, and the finder was objective in their assessment and determination of that finding. Versus maybe the same violation could be found through a compliance management system, for example, by way of a site having a written program in place for chemical approval. And in conducting a routine floor inspection, a chemical was found that failed to go through that chemical approval process. And since it didn't go through the chemical approval process, it missed all of those critical assessments relative to being assessed and then eventually reported on the TRI report. So that's a blend of there's a program in place for chemical approval. Hopefully that had some roles and responsibilities defined. We were doing a routine assessment and we identified the gap and we're now going to fix the gap. So that would be an example of using a management system to identify a finding. And then, I'm going to hand it over to Rita here in a second, but before I do, I wanted to just share one screenshot from the e-disclosure platform. And this is just to put a final pin in how important systematic discovery is in applying the audit policy. So this screenshot from e-disclosure, as you go through the disclosure process, you have to identify that you've met and certified that you've met each of the 9 conditions. And so this is just the screenshot for condition 1 of systematic discovery. And notice it reads, the violation was discovered as part of an environmental audit. And then it instructs, check each box that applies. All boxes must be checked to qualify as an audit. And you'll notice it's, again, using those same indicators, systematic, documented, periodic with future audits scheduled, and objective. Or it's got to be part of that compliance management system. And again, notice you have to check all the black boxes that apply. And for you to get credit, so to speak, both of those boxes have to be checked. So you've got those written policies and procedures that identify how employees are supposed to meet certain obligations. And then you've got overall responsibility for overseeing those compliance where you're defined roles and responsibilities, checking to make sure conformance, acting where you have nonconformance, training folks to those programs, and so on. So a critical piece there. And I'm going to hand it over to Rita here because as you are looking at um, implementing an audit program, or if you're looking at implementing a compliance management system, such as an environmental management system or an ISO 14001 system, to get the most out of the program, you might want to ask yourself, do we want to engage with legal counsel to gain any type of privilege through the discovery process? So, with that, Rita, I will hand it back to you.
Thanks, Jackie. On the issue of privilege, we should begin with the understanding that EPA's audit policy specifically states that the agency does not recognize a blanket privilege for audits. So, how do you protect any portions of the audit process or audit report? Um, there are circumstances where engaging legal counsel can protect portions of your audit. For example, if the audit was done in anticipation of litigation, there might be a dispute coming because of some kind of noncompliance issue. You might also be able to protect any legal communications about the contents of the audit, about whether to report, if you are working with outside counsel or in-house counsel to perform the audit. It is important to note, though, that you have a duty to cooperate. Jackie has already discussed that condition of the audit policy. So the underlying factual findings of an audit would not be protected. So it's a somewhat fact-specific analysis, but we have had some success protecting portions of audit reports and communications about those audits. I should note, though, that generally speaking, EPA does not proactively request copies of audit reports to trigger enforcement investigations. So that really shouldn't play into your concerns about whether to do an audit. But I do want to note that there is not a blanket privilege. And this is different from some jurisdictions where you may operate facilities, including South Carolina, where we do have a fairly broad audit protection privilege. So just note that going in. Next slide, please. In developing the audit policy, EPA worked extensively with state programs, partner agencies, and that's consistent with what EPA often does. It works with state agencies. It will share information with state agencies where appropriate to do so. This often occurs where states are running delegated programs. EPA will defer to states on penalty mitigation as well. This is very much a cooperative process. For that deference to occur, though, EPA has required those states to meet minimum requirements for the federal delegation of the programs it might be running. But generally speaking, more often than not, EPA is working alongside with state agencies. Many of the audits I have done have been primarily interacting with EPA, even though there was communication with the state agencies. Jackie, I'm not sure if your experience has been different, but there is an express cooperation built into the audit policy. Okay, I think we're ready to move to specific examples.
Yes. Now, test your knowledge at home. And so we're going to go through a few scenarios. And I'm going to ask Rita, what does she think? Should the site disclose or not disclose? And then we'll discuss and go on to the next example. And this first example we specifically picked, as I mentioned earlier, in the two types of disclosures, the two categories of disclosures. EPCRA by far is the most commonly disclosed item, and especially TRI reporting under EPCRA. From 2015 to 2017, I couldn't find more recent data, but from 2015 to 2017, 57% of all disclosures to the EPA were EPCRA related. So this is a common one. So in compiling information for the 2024 EPCRA Toxic Release Inventory reporting year, You identified that historically you should have been reporting chemical X, but failed to do so. So, Rita, what do you think? Disclose or not disclose? What would be your questions here?
How did you identify this issue? That'd be my first question.
Exactly. Is this systematic discovery? So this does not sound like an audit to me. This sounds like an environmental professional at a facility going about their day-to-day work. So it does not sound like an audit. So then I would want to see, does this site have an environmental management system or a compliance management system? Do they have ISO 14001 certification? Can we say that this was systematically discovered because they were following maybe a process or procedure that they have for EPCA reporting, and in following that procedure, they identified this gap? So there would be a couple of questions here for sure, to see, do they actually meet that systematic discovery? And I would just remind the audience, even if you don't meet systematic discovery, you can still disclose. Just remember, in this, if this was not systematic discovery, it'd be a category 2 disclosure, and you would potentially only receive up to 75% of the penalty waiver as opposed to the full 100% of the penalty waiver.
So this situation, probably yes.
Yes, you might still want to, and one thing that I like to think of relative to disclose or not disclose, is it something that a regulator could find as well, and could cite you, as well? And so EPCA reporting has paper trails, and it's low hanging fruit for inspectors. And so I'm with you, Rita. I would probably have the facility consider disclosing here, even if they don't meet systematic discovery, because the likelihood of EPA may be knocking on the door. Hey, I noticed this year you reported this chemical, but not in the previous years. Why is that? And so, right now we're in maybe a phase where EPA might not be as heavy-handed in enforcement. Something like EPCRA has statutes of limitations that can transcend different administrations. And so I would recommend to kind of go ahead and disclose it, find it, fix it, move on, so that it's not discoverable later, maybe under a different EPA administration that might be a little bit more heavy-handed with how they're assessing enforcement. All right. Next example. All right, same company, exact same company as example 2, or excuse me, as example 1. So same company and same location as that TRI reporting we just mentioned. So 5 months after disclosing and correcting the identified TRI violation, the same company identifies that they should have been reporting under the TSCA chemical data reporting rule, but failed to do so. So again, disclose or not disclose? Rita, what do you say?
The question that comes to mind here is, are these considered repeat violations? Remember, we cannot use the benefits of the audit policy if we have repeat violations at the same facility. My take on this is that these are different kinds of violations and would not be considered repeat violations that would trigger ineligibility under the audit policy. What's your take, Jackie?
Same. TSCA and EPCRA are two totally separate regulations. They might have similar compliance mechanisms associated with it, having a good understanding of the chemicals that you're manufacturing, you're processing, and you're otherwise using, having those good inventories, having those good records. The way you comply with these two regs might be similar, but they're two totally different regulations. So I agree. I think the burden of proof for repeat violation, I wouldn't worry about that one for this client. I think the systematic discovery question might still present itself, but this is another one. The TSCA reporting. This is the second most numerous disclosure under EPA, because again, it's got a paper trail. It's got a long statute of limitations. This report is only due every 4 years. So failure to report can transcend different administrations. It's an enforceable rule. Whether they can meet systematic discovery or not, I would recommend. But hopefully, maybe as a result of that last disclosure over example one, maybe they put into place a compliance management system, and they found this through exercising that new compliance management system. All right. All right. Example three, same company as example one and two, but now different location from example one. So same company, different location. A sister facility also identified that they failed to report chemical X on their TRI report. So what about now, Rita? What do you think now? Disclose or not disclose?
Well, remember the EPA also looks at compliance across facilities. So this one, you might still decide to disclose, but it would probably be ineligible for all of the incentives under the audit policy because this would be viewed because it's the same violation across different facilities within the same company. It would probably be viewed as ineligible for the incentives of the audit policy. Do you agree, Jackie?
I agree, and I'm going to add whether this is not going to be in that EPA disclosure checklist or user guide that we linked, but something that I like to advise folks before they start down the road for disclosure is go ahead and ask yourself before you disclose. Where else could this apply either at my facility or across my organization? And then maybe you can wrap them all in one disclosure at one time and gain those protections as opposed to piecemealing it across the organization. So that's just another thing to maybe fully utilize or best utilize the audit policy is before you start disclosing, do a historical compliance review of your facilities. Whether it was disclosed or not disclosed, was one of your sister facilities audited by a state or federal agency and they found this? That would be considered repeat. It doesn't have to be disclosed for it to be considered repeat. If EPA found it, that could be repeat as well. So go ahead and do that little part of a root cause analysis where you look at where else could this occur and you make sure that you fix it across the entire enterprise. In asking yourself that question, it might also help you identify at that disclosure phase how many locations might you be disclosing all at once. All right. Example four. You are new to your position. You dig into compliance programs and identify that you have a stormwater permit at your new facility that you're working at, and you have a pollution prevention plan for that stormwater permit. But you can find no records of the permit required quarterly visual inspections. So, what about this one, Rita? Disclose or not disclose?
So, two issues here, I think. The first is this just says you're new to your position. You're not a new owner. So I don't think we necessarily trigger the new owner audit policy, which does give us more flexibility. Um, but the compliance issue here is related to a permitting issue. Um, the stormwater permit and pollution prevention plan. So we know from Jackie's overview that permit violations are generally not eligible for the protections of the audit policy. And perhaps a more practical observation here is that you don't know there's noncompliance. You suspect there's noncompliance, but you simply cannot find records of previous inspections. And that would be incredibly difficult to correct if it was, in fact, an issue of noncompliance.
That's a great point, Rita. One thing, whenever we do audits, as a company, it's always important to note there are some things that we find that you really just can't fix. Things that happened in the past that you can't go back to quarter four of 2023. And so here, I think we're of the same mind that disclosing would not be very value added for the organization here. What I would more recommend for this organization is to put a memo in the file that on this date you were doing a routine assessment of your stormwater program and you could not identify records from the following dates. You just couldn't find them. And so um, you're acknowledging that you've exercised the compliance management system, and you just can't find the records. You're not saying you didn't do it. You just can't find the records to prove that it was done or not done. And really the only corrective action you have is just to put a memo to the file of you've searched and searched and searched and you just can't locate these records. And then just make sure, I believe this was quarterly inspections in our example here. So you just make sure you start doing those quarterly inspections and pave a way to prevent recurrence by having a good document and record control process moving forward. All right. Similar example here with a slight variation, and Rita did a good job of leading us in on this one. So now, not just new to the position, now you are the new owner of a facility. And same scenario, new owner of a facility, and you are digging into compliance programs and identify that you have a stormwater permit and you have a stormwater pollution prevention plan, but you cannot find those quarterly records. What about now, Rita? Would you recommend disclosure or not disclosure?
Almost always yes, when I'm working within the new owner audit policy, because it offers much more flexibility, a total fresh start, and it does not contain as many exclusions. For example, in the previous slide, we talked about how if you find a permit violation as part of routine compliance, that wouldn't be eligible under the audit policy for the incentives EPA offers. As a new owner, you can report those types of non-compliance issues. So almost always yes, if a new owner is doing an audit. Do you feel the same
Right.
way, Jackie?
Absolutely. My one caveat would be how new of an owner are they? And I would just remind our listeners that the new owner audit policy has to be exercised within the first 9 months following that purchase. So if we're within the first 9 months, then I would absolutely disclose. Even though it's the exact same scenario, right? It's not something that we can go back and fix. It's something that happened in the past, but you can find it, you can identify it, and you can pave a way forward to make sure that it doesn't recur again. And so you can start with that clean slate. So if you know, a year later, a state agency or the EPA comes in and audits, and they're asking for 3 years worth of quarterly records or the permit's life worth of quarterly records. Well, you're able to show the records that you've started since you've been the new owner, and then you've got that disclosure document that explains away the historical gaps there. All right. Last example. So here, through an environmental audit, so we're going to assume we've met condition one here in the systematic discovery. So through an environmental audit, your audit team identifies that you have processed wastewater that you thought was going to the sanitary sewer system, but is actually being released to the stormwater system and thus going to a nearby creek. Rita, what about this one? Disclose or not disclose?
Probably not here because issues that result in harm or endangerment to the environment are generally not eligible for the protections of the audit policy. Now, it's possible that no harm resulted from this, and if that is the situation, you might reconsider. But generally speaking, these types of discharges, if they created environmental harm or endangerment, would not be eligible for the protections of the audit policy.
And this is one in my mind is a great example of why as an environmental consultant and as somebody that does a lot of environmental compliance audits, when we have findings that are similar to this, I love it when we're working under attorney-client privilege because these are very sensitive findings. The vast majority of the findings that I feel like we have when we do environmental audits are kind of awareness in nature, documents and records in nature, are easily fixed. But issues like this are much more sensitive. And so to know that we have, as you mentioned, Rita, it might not be a complete shield, but the protections that attorney-client privilege can afford when we have a finding like this, it just allows for that counsel straight from the beginning and allows for a smoother path forward, even if disclosures is not a part of that path.
And I should note here that you might have other disclosure obligations if, in fact, there was harm. You might also want to disclose to avoid any kind of criminal enforcement proceedings, but this would not be eligible under the audit policy, generally speaking.
Correct, correct. All right, great. So now we would like to end with just some best practices and recommendations for those of you that might be considering future disclosures or audit programs or compliance management systems. So ensure you can meet the burden of systematic discovery. So if you're sitting in this webinar right now just to learn more about the audit policy and you don't have a real world situation you're navigating of disclose or not to disclose, plan for the future and plan for a future where you do identify something that needs to be disclosed. And in planning for the future, go ahead now, either establish an audit program or establish a compliance management system. And again, compliance management systems would include what we call an environmental management system or an ISO 14001 environmental management system. So plan for the future, have those systematic discovery tools in place. So if you find yourself in a situation of disclose or not to disclose, you at least have that very first condition taken care of. And then consider whether you want to have counsel involved in that audit process. It's not going to hurt to have them involved. It might offer some protection, might offer some wise counsel there in the beginning. Even if it's not a complete shield, it could provide you some protections. And then, Rita, what about you? What are some of your recommendations?
Just a couple of notes. You probably already picked up on these, but it's worth reiterating that you must be mindful of deadlines. This program is beneficial, but it is also based on quick correction, quick disclosure, and quick correction. So you have 21 days to disclose and 60 days to correct, and those both run from the date of discovery. That can run very quickly. Um, Final lesson, just ensure that what you learn from the process can be shared across multiple locations, particularly if your entity is operating across different facilities, because we would not want to be ineligible for the audit policy protections because of repeat issues.
Great. Thank you. And so with that, we have a few closing remarks. And in these closing remarks, that will give you some time to enter in some questions or to think about some questions that you might have. So in some of our closing remarks, first of all, thank you, Rita, for joining me in today's webinar. And for our listeners out there, I wanted to let you know we have our September webinar already scheduled as well. And this is a topic that is pertinent not only for electric vehicles, but also for even folks within the aerospace industry, really anybody that uses the batteries and the battery assemblies that have magnets associated with them. And in our September webinar, we'll be talking primarily about those magnetic fields as an emerging occupational hazard with those, whether it's EV or even in some of the aerospace and other industries that have those battery assemblies and the associated magnetic fields. So we'll be going through those emerging hazards and controls in our September webinar. We have in-person training coming up. Our Connecticut office in Farmington, Connecticut is going to be hosting some in-person training on October the 9th. So anybody that happens to be in that area that is looking for RCRA hazardous waste training or DOT transportation of hazardous material training, please don't miss that training opportunity. We also have numerous topics that are available at your convenience online. And then also all of our past webinars that we've offered this year are available to you as well through YouTube. And the handout that we provided with all the tools and resources and links and definitions at the very bottom of that handout are links to our YouTube channels and the recorded webinars that we've presented throughout this year. And feel free to scan the QR code just to go straight to our training page if you have any other training needs. And so give me a second here. I'm going to navigate to our questions and chats, and I'm going to leave it here on this slide. If you have a question or something you wanted to talk about but maybe it's too nuanced to type, or you just don't feel like typing all those details, you have both mine and Rita's contact information there. Feel free to reach out to either of us at any time should you have any questions or comments, not only about applying the audit policy, but any maybe compliance concerns that you might have. All right, so let me take a quick look at some of the questions. All right, one question that has come in. We talked about the EPA audit policy. Does OSHA offer similar protections? Um, Unfortunately, no. So, Rita, I don't know if you've been involved in any similar situations with OSHA, but unfortunately, OSHA does not have a similar audit policy that has similar incentives. I don't know, Rita, if you've had experience with OSHA, if you want to elaborate on that at all.
And my experience is the same, that the EPA
Mhm.
policy is much more generous than what many federal agencies offer.
Correct, correct. So yes, this is um, a a special edition only for EPA. So unfortunately, cannot apply it to OSHA. And I would just say if you're developing an audit program, and in your audit program, you're going to be looking at both environmental compliance and health and safety compliance, then I would, asterisk again the consideration of involving whether it's in-house counsel or outside counsel, to maybe have some of those attorney-client privileged conversations because you're not going to have any benefit under OSHA for a self audit. All right, I think that was our only question. So, with that, we will go ahead and log off, but please feel free to reach out to Rita or myself if we can answer any other questions. And again, Rita, thanks again. Good luck to your Clemson Tigers this weekend. And to all of y'all who are hopefully looking forward to a long holiday weekend for Labor Day, I hope you have a wonderful holiday weekend. Thanks, everybody.
Thank you all.